am. Are you sure? Because I told you one aspect.
It's moving. Okay.
Pretty sure it doesn't feel. Oh no, I think it's just that it's not. Alright,
Testing. Testing.
all right. Are you good for me to get started?
I'll be sitting right there.
Yeah.
Since we're already running late.
Yeah. We have 90 minutes, so I think we're probably good. Make it work. All right, I'm going to get started. So, just a note of apology up front. I have somehow injured myself, so I may end up sitting, but I'm going to try and do this standing as much as possible, and we'll see how we do. So, thank you for coming. So, my name is Jen Ellis. At the moment, I also go by Hopalong and possibly the Gimster. I work at Rapid7, and I work with... Is there any chance we could close the door? Sorry. I work with a huge number of security researchers, both within Rapid7 and across the community. And that's relevant because it's going to come back to like how I got into cybersecurity legislation and what I'm doing there. I'm not a lawyer. That is kind of important. You do need to know this because nothing I tell you is going to be legal advice. And I'm not even really a lobbyist. And worse than that, I'm British. So the first time I turned up to DC with my sort of Mr. Washington naivety, I asked whether congressmen work for senators. It was a good day. So I really have no credentials to talk to you whatsoever, except for the fact that I am doing stuff. And in fact, this is me testifying to Congress. This is my moment of self-aggrandizement. So yes, this is me testifying. I testified about 6 weeks ago. And I testified about the impact of the Computer Fraud and Abuse Act on security researchers. I want to talk about that a little bit more through the talk. So yeah, embarrassing picture, there it is. And the CFAA is basically my gateway drug. So this is how I got into legislation, and then we'll talk about some of the other legislation that I work on. So during the course of this talk, and we have a long session, we have about 90 minutes, we're going to talk about what some of the proposals are, what some of the current law is, and some other sort of non-legislative developments, and then we'll talk about how you guys can get involved. My goal is to spend the time sort of half and half, like me talking at you, and then lots of time for questions. So please do kind of think about what your questions will be and get ready to ask them. A couple of things. I'm going to be focused on security, not privacy. They do obviously overlap, and there will be times when I talk about privacy issues, but mainly my focus is on cybersecurity. And I'm also not going to touch on vertical-specific regulation, things like FISMA, that kind of thing. I'm going to just pause now in case anyone wants to get up and like hurriedly get out the room. Oh, all right, good. And just another sort of context-setting moment. I'm going to be using the word cyber. You guys are probably... Thanks, Todd. Hi, Todd. And I know that doesn't always sit very well with security audiences, and I understand why. It's because you know what the internet is. But at the same time, this is the language that is used in DC, and since this talk is all about what's happening in DC, I will be using the word cyber. Deal with it. So before I get into the sort of ins and outs of what's happening, I kind of want to address some some context around, our community and how our community thinks about legislation. I work really actively in DC trying to build collaboration between the security community and the DC community with a view to the fact that they're paying attention to cybersecurity right now, and that's not going to change. It's going to continue, and it affects our lives. And we have the ability to shape that. There is a lot of discourse in our community about the government being idiots, not knowing what they're doing, being out to get us. I'm not going to be indulging in any of that. And so if that's the talk you're looking for, not the talk for you. The reality is they know their world. They don't know our world because it's not their world. And it's our job to help them understand. So what I'm going to be talking about is like how we can do that and what a role you can play in that. I'm trying to make this sort of actionable and constructive. I'm a big believer in trying to be part of the solution, not just jumping up and down and pointing out the problem. So, the other thing I should warn you about is I really like audience participation. Sorry. So, does anybody want to take a guess about what this is? What this number represents? Go for it. Good guess. Nice guess. It's not. So the guess was that it's a number of an act. So Congress.gov lists all of the pieces of legislation that are proposed and passed. You should check it out if you are interested in what the legislation is. So I put cybersecurity in as a search term on Congress.gov and clicked the button that said legislation. And there are 519 pieces of legislation in Congress.gov's library that have the word cybersecurity in them. So basically, the gist here is that cybersecurity is a very hot topic in DC. It's not going to stop being a hot topic in DC. It's going to continue to be relevant in a lot of people's lives, and we are going to see a lot of people coming up with proposals. In fact, in the 114th session, which is last year into this year, we've seen 64 pieces of legislation proposed, just in that session. And that's just a vast number. And so, like, everybody on the Hill at the moment understands that they need to have some sort of agenda around cybersecurity. It's not going away, and it impacts our lives, and we need to know more about it to sort of take control of our own destiny a little bit. So as a sample, because, there are 64 pieces and I can't put them all up here, but this is just a sample. So how many people have heard of one of these? Most people in the room, great. How many people have heard of 3 of them? Okay, has anyone heard of all of them? I've worked on all of these this year, in some capacity or other. So these are all things that are being actively discussed at the moment. So what are they about? What do they mean? So they basically break out into a few different main themes. The biggest theme at the moment in legislation around cybersecurity is around information sharing. Now, there is a certain amount of dialogue in our industry that the reason for this is that the government is trying to find a way to get information out of us. I don't know if that's true or not. My conversations with people have not really revolved around that. I think that what the government is trying to do is the government is desperately trying to find a way to address the cybersecurity problem with sort of a limited amount of background and experience and context in doing that. And also within the framework of government, which in and of itself is limiting. There's only so many things you can do. And to make legislation like incredibly prescriptive, for example, is really limiting because it takes a really long time to change law. So they're trying to look at ways that the government can actually play a role. Information sharing is interesting because there's a perspective that increased transparency helps us. It raises the tides that rises all ships. I can never say that. The thing with the tides and the ships. So we all get better by knowing more things. Yeah, don't use phrases you can't say. That guy has it. The rising tide raises all ships. Round of applause for you. Thank you. So that's their basic principle, but the reality is that very few organizations are actually set up to take advantage of information sharing or participate in it. Maybe like 5%, right? So like really big financial institutions, really big retailers, people in the intel community. So the government is looking at this and thinking, the government can play a role by basically taking the work that the 5% is doing, which includes the government itself, and then helping to disseminate that information to the other 95%. That's the general thinking. That's not actually that bad a goal. That's actually a decent goal. The challenge is how they implement that. And the problem that you have with it is around privacy concerns. That's typically the number one problem. Government abuses is another concern that people have. Then there's sort of a lot of discourse around countermeasures or hackback or defensive measures, and that's another concern that people have. So where we are with information sharing right now is that there was a cyber week during RSA. Funnily enough, they're now looking at doing another one this week. And during that cyber week, there were 2 House information sharing bills that went to a vote on the floor. And they won. They were overwhelmingly passed. One came from the House Intel Committee and one came from House Homeland Security. And those are actually decent bills. They're pretty decent. For the goal they're trying to achieve, they're good. Now we're at a stage where the Senate has their own bill, and that bill is called the Cybersecurity Information Sharing Act, CISA. Has anyone heard of that? Great. CISA is a little scary. And actually, this is something that I think a lot of security people do care about, because there are some concerns in the implementation and the wording of CISA. A couple of those are that there's been concern over, there's a piece in there that basically says you give your information to the government and, I missed a really important piece about information sharing. So the basic foundation of information sharing bills is that if you share information, you will have liability limitation. This is part of the reason that they're actually trying to introduce a law to do this. So the idea being that if I'm an organization who's had some sort of attack and I take the information from the forensics on that and I share it with the government so that other people can learn about the attack style, and somehow a piece of PII gets mixed up in that I'm not going to be liable for the fact that I've shared PII, provided I took reasonable measures. And where a lot of debate comes in is around the concept of what reasonable measures are. And how you should protect PII and whether it's okay for it ever to be shared. So that's one of the issues that comes up in CISA. Another issue that comes up in CISA is around the idea of you give your information to the government and then they can use it and share it how they like. Now, that is actually pretty concerning, and there's been a lot of debate around it. And right now, there is a manager's amendment that is being proposed. Why do I keep bouncing down? That right now, there's a manager's amendment that's being proposed for CISA that would address that piece around how information can be shared and would try and limit it. And as I said, defensive measures is another thing that people are looking at that is creating some concerns around the potential for abuses. So there are definitely some issues with CISA. There's been talk of it hitting the floor this week. We will see it definitely hit the floor this year. And there is very, very, very strong commitment amongst certain groups to see it passed. So this is something that is probably on the top of the list for most congressional staff in terms of cybersecurity legislation. So it's an important one to be aware of. Yeah.
What happened to the Antitrust red balloon that was being floated about all these information sharings?
So the question was, what happened to the Antitrust red balloon? That was.
Red flag.
I think that actually the way that the information is being shared, the way that they've set up for the information to be shared addressed the antitrust issues, and this keeps bouncing around. But I would need to go and talk to people specifically about it. But I'm pretty certain that's what happened. Is there's limits on, or there's descriptors of how the information is shared that deals with the antitrust issue. So breach notification. So there's been a number of people who've come out with breach notification bills, both on the House and Senate side this year. The general principle here is that we have 47 different state breach notification bills. For an organization who is operating across states, that's kind of a headache to deal with. For consumers, it's hard to know necessarily where you stand, and it creates a sort of disparate level of response to breach situations. So what the government's trying to do is come out with basically one ring to rule them all. So there's been some debate around how we do this, and generally speaking, the debate revolves around whether we preempt the state laws as a ceiling or a floor. So the idea being that either you set a minimum standard that everyone has to achieve, and then any states that are above that, they get to keep their state law, or you set a standard and you say, this is the standard, this is it, and no state laws exist outside this, or no state laws apply outside this. The civil liberties groups are very active in this area because of the potential impact for consumers, and their argument is that the state laws that are stronger should stay in effect. And the reality is that state law moves faster than federal law. It can be changed faster. So that's the basics of the argument around breach notification. I think it's probably unlikely we will see a breach notification move this year. I may be wrong, but I think that's fairly unlikely. Oh no, there's a member of the government here. Okay, so then the next three I will group together. So data protection, liability limitation, and cyber hygiene. The basic gist of this is, again, we need to do something about cybersecurity. What can the government do? How can we get involved? How do we prevent cyber attacks? So they're trying to set a bar for how organizations think about protecting data, the kinds of things that they do, to the kinds of technologies they use, the kinds of tactics and policies they put in place. They're looking at limiting liability as a way of incentivizing good behavior. And the language that's being used a lot is around cyber hygiene. The biggest challenge with any bill in this area is the idea of how you do this without making it incredibly prescriptive, and how you create a one-size-fits-all approach. I think it's, again, pretty unlikely that we'll see something in this area move this year, but it's worth sort of taking a look at. In terms of the kinds of bills in this area, just going back up, so the Cyber Supply Chain Management and Transparency Act would fall into that bucket. That would probably be cyber hygiene. The Protecting Student Privacy Act, Spy Car Act, Safety Act, and the CPPA, Consumer Privacy Protection Act. Those would all fall into that bucket. I think the ones that have the better chance of passing are probably the ones that are narrower in scope. So something, for example, like the Spy Car Act, which focuses really specifically on security and privacy relating to cars, that might have a better chance of passing than something that's a little bit broader in impact. So then this takes us to the last category, law enforcement authorities. So there are a number of things. Oh, sorry, you had a question?
Since technology moves so much faster than law, why do regulators think that static legislation is likely to resolve technical limitations?
So the question is that since technology moves faster than law, why are legislators trying to get involved, basically? The reality is it's their job to get involved and to try and find solutions, but you've hit the nail on the head. That is exactly the challenge that they face, and that's why it's really hard for them to create law that's prescriptive. And so, like, even something as simple as, if you look at the breach notification laws, a lot of them will have something in there about you being exempt from liability if you have, or not exempt from liability, exempt from notification if you have strong standards of encryption applied to the data that's been accessed. And yet, the language around that is hard, because what is a strong standard of encryption today will not necessarily be the strong standard of encryption in 5 years' time. So they definitely are aware of that being a problem, and they're trying to create a framework that is prescriptive enough to be meaningful without being so prescriptive that it's limiting and becomes obsolete before it's even passed. Yeah.
With past technical areas like telecom,
Yeah. There is also a lot of focus on, so the question was that in other technical areas like telco, there are agencies that deal with it that can move faster. So there actually are pockets of that kind of thing happening. There are pockets of non-legislative approaches, and there's also pockets where, if you look at the telco sector, there's agencies that basically run it day to day and decide what needs to be done, but then there's legislation that says, and this agency will own it and it will do this. So that's basically the model they're trying to deploy. So, for example, in a cyber hygiene bill, they might say, you should follow NIST, that kind of thing. And that, NIST framework comes out of the Department of Commerce, and is able to be adapted on an ongoing basis, which the legislation probably isn't to the same extent. Does that answer your question? And then you had a question.
All right. The Capitol Hill trying to pass all these acts and all that. You were mentioning how your job is trying to steer them in the right way. How much? And he also said that technology moves faster.
Yeah.
So my question is how would you make it so? Because if they don't understand that much, and it keeps getting, and they're trying to control it, the acts, how do they know what to do? So what, like they're going in the right way. That's what you're saying, but how do they know what to do?
So that's where people in this room come in. This is where. So the question was, given the complexity of the topic and the fact that they're not experts, how do they figure out what to do? So that's really where we all can play a role, and really it's about us helping educate them. So they're only ever as good as the information they're given by the people who are trying to talk to them. And this is why, people are very cynical about government, is because there are big companies that have big lobbying budgets, and those companies are the ones that are influencing legislation because the staff are talking to them. But that's not because the staff don't want to talk to other people. That's opportunity. That's the opportunity they have. So if there are people who want to get involved and are, prepared to actually sit down and have a conversation, then the staff generally will be very, very open and receptive to that and actually grateful for that. So it's a question of how people can connect those dots to help with that process. And a really big part of it is making it simple for them. The average staffer works on a vast number of issues. So I'll brief anecdote. So the first time I did a trip to DC to do any of this stuff, as I said, I had packed my suitcase, headed to DC like Mr. Washington, and I get there thinking that we're going to have these great meetings and I'm going to be really impressive and compelling and people are going to pick up the rights of the security researcher and burn the CFAA to the ground. And what actually happened was the day I got there was the day that healthcare.gov fell over. And I literally sat in meetings while people watched the news over my shoulder and I was like, okay. And regardless of which party you were in, you cared about that news, either because it was a bad day for your party or because it was a great gleeful day for your party. And so there was a high degree of distraction that day, and it couldn't have been a better thing for me to see. It was the best point in my education that I had in the entire process, because it was the moment when I realized that for staffers, they have so much shit going on. At the same time, they were talking about immigration. They had Ebola at the same time. And I was sat there going, so security researchers feel that they're getting a hard time. And they were like, have you heard about the people dying from Ebola? So it was kind of good for me to have that moment of being like, oh yeah, there is other shit going on in the world. And it's important for us to think about the fact that staffers are trying to cover a vast number of topics, and they're doing their best, and so we need to help them, and we need to make it as simple for them as possible. So law enforcement authorities, there are a number of options in this area, but the main one that I will point to is around CFAA reform. And we're going to talk a little bit more about that in the next section, so I'll park that there. But the number one bill in this area is the International Cybercrime Prevention Act. So basically, in January, President Obama said, cybersecurity is a huge issue. We just had the Sony hack. We need to do something about it. And the White House came out with 3 proposals that they said they would like to see turned into legislative drafts. One was around information sharing, one was about breach notification, and one was about extending authorities for law enforcement. And the information sharing we already talked about, it got picked up, there are a number of bills, CISA is going to happen. Breach notification we talked about, there are a number of people who have something that looks like that. So the last one, the law enforcement one, has been the slowest one to come. But there are now people working on it, and it's coming out of Senate Judiciary, and it's called the International Cybercrime Prevention Act. And basically it does a bunch of things. It updates a number of existing laws, and it does things like it gives law enforcement the authority to shut down botnets. It applies RICO to cybercrime. So for people who don't know, that's an organized crime statute. It basically means that if you are part of a criminal organization and you commit a cybercrime, then they can sort of connect the dots, and they can go after other parts of the organization. It does things like it has specific sections in it for how trade secrets are treated and how the sale of financial information internationally is treated. There's something around critical infrastructure and the protection of critical infrastructure. But the really big section in it is a piece on updating the Computer Fraud and Abuse Act. So I'll talk about that more, but you guys should definitely check out the ICPA. I highly recommend you take a look at it. There is an old copy of it available on the CDT's website because it's not fully public yet. So there's a leaked old copy of it there. You should check it out. So, current laws that affect security. Does anyone know what this is? Yep. What? It's the CFA, yeah. I talked about it enough. So, I got interested in, does everyone know what this reference is, by the way? Yes, thank you. Okay, so the reason that I have a War Games picture up here is, and this is not a joke, unfortunately, tragically. The story goes that President Reagan watched War Games and said, oh, that's quite scary. We need something that deals with that. And thus the CFAA was born. And so I got interested in it. As I mentioned at the beginning, I work with a lot of researchers. And one of the researchers I work with, a guy called HD, he and I had been working on a research project for about 9 months. Now, in full disclosure, he had been working on a research project. I just kind of helped him tell people about it. And we'd done a bunch of disclosures. We disclosed some pretty interesting stuff, things that impacted millions of people, some real issues. There was one thing that meant you could blow up churches in England. Why is it always England? And so, it was a bona fide research project with some pretty good outcomes. It had a web page. It had a way of opting out. It was pretty legit. And HD has a pretty decent reputation in the security community. He's worked with law enforcement. He kind of fits the criteria of what a bona fide researcher looks like. So imagine our surprise when it turns out that a prosecutor is going to investigate him. And that prosecutor actually investigated him for 3 months. Despite the fact that the FBI said, no, we've taken a look and we think it's all kosher, the prosecutor investigated him for 3 months, and that was a incredibly stressful 3 months in HD's life. And so at the end of that, when the prosecutor decided to drop the case, HD kind of said, I'm sort of done. I don't really want to do research anymore. It's too much of a risk to my family, and I couldn't really say, don't be an idiot. We should carry on doing the research. It's great, because it was his risk and not mine. And so I was like, okay, fair enough. And then I kind of got thinking about it. So my shameful confession is that I am not very technical. Sorry. B-sides room. Not a good time to tell people that. And so I kind of went away and I thought about it, and I was like, here's the thing, right, is that as somebody who's not very technical, I kind of rely on the work that researchers do. I rely on the discoveries and the insight and the ability to make informed choices as a result. I have an iPhone because somebody told me that Android's not that secure. And I would never have been able to figure that out for myself. So for me, I feel like security research is a consumer rights issue, and a consumer protections issue. And so after I thought about it a little bit more, I kind of said to HD, I get that the risk is really bad, but I think that the work that you do is important. I believe in the value of security research. And so we met with a phenomenal lawyer, Marsha Hoffman, who I highly recommend for anyone who's in need of legal counsel in this area. And I remember it really clearly. It was at Black Hat a couple of years ago, and we were sat in Caesars, and she was telling me this story about how Reagan watched war games and decided that he needed a law. And she said, it was written in 84 and passed in 86. And I'm sitting there and the words are filtering through my haze of, Black Hat hangover. And I kind of look at her and I'm like, hang on a second. The main cybercrime law in the US was passed in 1986. She was like, yep. I was like, so it has been updated. It's been updated a number of times, not adequately. And so there are a few issues. One, it is out of date, regardless of it having been updated. When I say it's out of date, an example would be that when it was written, there was this sort of distinction in there about accessing protected computers. At the time, a protected computer would be a great big physical thing stored in a secure building with a fence around it. Now, does anybody have a protected computer that is not protected? Anybody in this room have any kind of computer that is not protected in some way? All right. So the distinctions are out of date, and it basically means that it's hard to know where the clear boundaries are. Second issue is that it doesn't define things very well. So the CFAA basically hinges around the concept of authorization. It's either that you have accessed something without authorization or that you have exceeded authorization in accessing something. And yet, authorization is not defined anywhere in the CFAA. That is a problem. So frequently what happens is we will go to Marsha and say, we would like to do a piece of research, is this okay? And she will say, I can't tell you that because there are no clear boundaries, and so it's hard to know whether it's okay or not. Third problem with it. The third major issue with the CFAA, and this is a doozy, is that the CFAA contains both criminal and civil action. And how many people have ever been threatened with legal action that relates to security? A lot of hands went down then. Okay, so of the people who've been threatened with legal action, how many of you have been threatened by some kind of law enforcement? Okay, so the rest of you, I'm guessing it was civil action. Right. So this is a huge problem. By far and away, the broadest application of this law is by private entities who take a fairly defensive stance over research disclosure, and they use the law as a sort of handy stick to beat off researchers. It was a weird choice of words. Oops. So, again, another awkward confession. I have a background in reputation management, which means that I am that idiot in an organization who has previously gone, oh no, I don't like this looks scary, we should make it go away, what can we do? And so the reality is that when you are in an organization, when you're in a technology provider, you have a responsibility to your employees and your shareholders and your customers to stay in business, stay profitable, stay on track, deliver what you promised, that kind of stuff. So you take an approach where you think that you have to do the things that are going to keep you productive. And when a researcher comes to you and says, your baby is ugly, not only are you kind of slightly offended and defensive about it, but you actually also have an issue whereby you can't really afford to take resources and put it into fixing the issue, and you're not even sure that your customers really want you to. So I get all of that. That is the context in which we live. Unfortunately, because of that, because we have that culture at the moment, and we haven't yet moved in a widespread way, there are outliers, obviously, that have bug bounties, etc. But in a general sense, we haven't moved to a point yet where there is a cultural shift and organizations are, on a broad level, embracing research. So as a result, the fact that they have this handy stick called the CFA is a problem. So a lot of what I do is I basically try to convince people that we should seek some kind of reform attempt for the CFA. The Dmca is the next slide. So what I would like to see is I would like to see greater definitions and clear boundaries. That would be a basic start. It wouldn't exempt research. It wouldn't solve the problem in the broad scope, but it would mean that there would be less uncertainty. It would mean that you guys would actually know where the line is, and it would be easier to toe that line if you can actually spot it. I have a weird belief that laws that affect people, or govern them, I should say, should be understandable to those people. So that's the basic thing I would like to see. Second thing I would love to see is I would love the CFAA to be criminal and not civil. That would address a huge amount of the issues. And the third thing, if I was, if I had a genie standing in front of me, I would exempt security research. The problem with that is there's no clean way of doing it. Because by its very nature, security research looks like bad guy behavior.
Can you just refer to intent to do harm?
No. They have tried, and that's one thing I do want to tell you is that there are people who are actively trying to do this. There are people who we talk to all the time who are trying to write exemptions, and they're really smart people who work in government agencies who understand the issue and care about the issue and care about research, and it's just not straightforward to do. Because any attempt at doing it around intent basically creates a backdoor for bad guys. And so a couple of suggestions that I've had as I've been going through this process that people have said to me or that I've come up with, we've worked on. One, registering researchers. So exempting a group of people. Who likes the idea of being registered? Yeah. And actually, fundamentally, it doesn't solve the problem because it doesn't allow for accidental discovery. Two, exempting behavior based on best practices. So if you follow this list of activity, then you're okay. Anyone like that idea? Yeah, it changes its context, and the problem is as soon as you create that box, it basically means anything outside that box becomes bad activity, which is not right. So that's difficult. Intent, very, very hard to draw a line around in this context. And by the way, the CFAA is actually an anti-trespass law. If you talk to anybody in the legal profession, they will not describe it as an anti-hacking law. They will tell you it is an anti-trespass law. And trespass law, by its very nature, is intentionally broad because you want to have a catch-all for any situation where somebody encroaches in your space without permission. And so when you talk to lawmakers about narrowing it, they're not keen because it is meant to be very broad. And trespass law also doesn't include intent. So that's some of the challenges with the CFAA.
I'm curious, have you looked at the regulations that stand behind these laws? Because I had to go into a situation where I learned a whole new set of laws because I was in a new vertical. Why don't you slide? Hi there. I had the experience of going into a new vertical, so I had to learn a whole new set of laws. And then I jumped into the regulations, and I found that the regulators may have written something into the regulations which have the force of law, but it's completely different than what was actually in the black letter law.
Yeah.
Have you looked at CFAA and seen if it's expanded inside of there?
So there are no that I'm aware of regulations that that basically impact this. but there are other attempts at law that would impact it. So at the moment, and it might change, but there, to the best of my knowledge, there are not regulations that speak to this piece, because the CFAA is not about how organizations protect privacy or what they do themselves, which is what regulation would normally speak to. It's about how law enforcement attacks, or not attacks, that's the wrong word, how law enforcement pursues cyber criminals. But there are other bills that affect this. So, for example, some of the things that are being proposed in CISA, which we already talked about, they would potentially impact the CFAA. So it is sort of all very interwoven and overlapping, and it does create a massive headache in trying to understand a lot of pieces of legislation. And again, I'm not a lawyer. Any other questions on the CFAA? There will be lots of time to ask questions at the end as well, yeah.
CFAA. Are you aware of any Are you aware of any existing specific proposals about better defining authorized access and essentially machines that provide services, which is now pretty much every machine in the world?
Yes, so there are a number of lawyers and law professors, legal experts who have debated it. Oren Kerr wrote a paper that's kind of well known in this area that talks about authorization, and I actually recently went on a bit of a fact-finding mission on this because I wanted to propose some language. There's a lot of dissent within the communities that relate to this area and talk about this area on finding a good proposal. And that is actually part of the challenge. Generally speaking, when you talk to Hill staff, if you can make a recommendation and you can make it sort of easy for them and you can explain why it's valuable and important, they will really, really entertain it. Whereas if you go to them and you're just sort of complaining about a problem, it's much harder for them to know how to deal with it, particularly as this is a complex area. So when I talk to people about it and they say, well, how should we change authorization? And then I go, well, let me send you 60 pages of different suggestions from people. That's where they're kind of if you guys can't figure it out and agree amongst yourselves, then what are we going to do? So that is definitely work that I think our community needs to be focused on and trying to identify some sort of compromise. And we are not, by nature, a community that embraces compromise all that well.
Is there an organization for that?
Okay.
There is. The American Bar Association actually has a federated identity and authorization task force.
Awesome.
I'm a part of it if you want to know more about it, because we have some state level laws that are starting to, Virginia's just come up with one on federated identity. So there is, and we would love to have more computer scientists participating in the task force.
That's awesome. That's good to know. And I will definitely be talking to you afterwards. Yeah. So, there are, like I said, lots of people working on it. It's good to hear that the American Bar Association is working on it.
Maybe not so good.
Well, again, it comes down to us to help with that, right?
Real quick, have you heard of the project Fork the Law?
Sorry?
Have you heard of the project Fork the Law?
No.
They don't look like they've been particularly active, but they have made some efforts in revising the CFAA.
Oh, great.
And you might find any of their past progress useful.
Yeah, I'll check it out.
Maybe bringing this forward.
Yeah, that would be great. Thank you. I will check that out. And there are, I think probably, how many of you have heard of Aaron's Law? Okay, so, Aaron's Law is the most famous CFAA reform attempt. It actually wouldn't necessarily help us. It would in that it creates a better definition, so it gives us a starker line, but the issues that Aaron's Law is really trying to address aren't really around security research, and so it's not necessarily the best proposal for us. It's also, realistically, never going to pass. So we should look at other attempts. Okay, so, DMCA. Does anybody know what the DMCA is? Okay, who wants to volunteer to say it? Thanks. The DMCA is the Digital Millennium Copyright Act. So this is another one that affects security research. I clearly am a little bit biased towards research issues. The interesting thing about the DMCA is that it is owned by the Library of Congress, which makes no sense whatsoever. So basically, the idea of the Digital Millennium Copyright Act is that it will, much like it sounds, it will help protect copyright. And basically, it's trying to say that you cannot circumvent technological protections and that is a violation of copyright. And for researchers, that's a problem. So if you're looking at researching a thing, like a car, maybe, seems to be a hot topic at the moment, then you are probably violating some part of the DMCA. Now, the thing that's interesting about the DMCA is it has exceptions and exemptions. Confusing, helpful. The exceptions say that you can do things like you can reverse the hardware for the purposes of security research. You can look at the encryption of data in transit. But you cannot do stuff like look at the firmware, which is great because like software never has bugs. So the other thing that's the exceptions. Now the exemptions are interesting because the exemptions basically when they created the DMCA, they said, okay, technology moves fast. How can we future-proof this bill? And so they have a 3-year rulemaking window. What that means is every 3 years, you can apply for an exemption. You apply to the Library of Congress, and you create language that would be your exemption. And they take all of these in, and they go through a process of public comments, and then they have hearings where people testify about them. And then they, some time later, they think about it and they come back and they say, we will grant this number of exemptions in these areas. And when you get to the next 3-year marker, those exemptions go away, we go back to 0 and we start again, which if you've had an exemption in is really frustrating because you have to go through the battle every 3 years. So we're currently in the middle of one of these rulemaking processes. And there are some security research exemptions that were filed. So there was one for cars, there was one for tractors, there was one for medical devices, and then there were a couple that were just like broad reach, security research, if it impacts life, we should care about it kind of stuff. The issue with this that is frustrating for a lot of people is that security research should not be an issue of copyright. And the Library of Congress actually really shouldn't be involved in determining this question. It's actually kind of completely beside the point. It kind of misses the core of what we're talking about. And here's the thing. There is copyright law. It's not like this is the only copyright law. So this is a law to protect the existing copyright law, which kind of makes no sense. So personally, I would like to see major DMCA reform in general, but at the very least, I'm hoping that we will see some great exemptions for security research come out in the next rulemaking. We're expecting to hear back from people in the fall. So that's when we're expecting to hear back from the Library of Congress, and we'll know what has and has not made it through. But generally speaking with DMCA, this is a topic that you should care about if you do any kind of reversing. And really, we want to see DMCA reform. There is a bill that has come out that would reform the DMCA, particularly specifically to help with research. It's very, very unlikely to move anytime soon. And it's called Breaking Down Barriers to Innovation Act. So, that's the legislation stuff I'm going to focus on. You guys can ask me questions after, at the end. But in the meantime, I thought I would talk a little bit about non-legislative approaches, some of the stuff that's going on. So, generally speaking, a lot of this is around trying to build better collaboration. The reality is that for us to solve these problems, we all need to work together. And as we already discussed, legislation may not always be the right approach to solving these problems. The technology moves way faster than the legislation can. So there are a number of people who have initiatives that are non-legislative to try and create better collaboration and solve some of these problems. One of them will be talked about in a talk later today from the Department of Commerce. Alan Freeman, who's speaking on that, is actually sat at the back of the room waving. And so Alan joined DOC recently as the Director of Cybersecurity in NTIA. And his goal is to try and create better collaboration with the security industry. His goal is to basically try and find ways of tackling some of these big challenges that we're all talking about. So the first project that NTIA is going to be leading off with, am I actually stealing your thunder by talking about this?
No.
Okay.
I assume no one here's going to bother to my talk this afternoon.
I'm sure they all will. I think it's also public information, right? So the first project, which will be a multi-stakeholder project, project, will be around vulnerability disclosure and trying to develop best practices on both sides of the house. So, like, how should vendors handle vulnerability disclosure and how should researchers handle vulnerability disclosure? So that's one example of a kumbaya moment. Another is there is a group that I work with who have been working with the Department of Justice for a year, actually. We first met to start this project at Black Hat last year. And our goal has been to try and help CSIPs understand some of the issues and to try and look at whether we could maybe create something like prosecutorial guidelines or some sort of best practices that would be endorsed by the Department of Justice. And at the moment, like, we're still sort of, figuring things out, working together, looking at what can and can't be done. Again, legal framework is very limiting, and there's only so much that can be done. But the dialogue and the consistency of the dialogue and how long it's been going on has been fantastic and very promising. And it means that when people on the Hill go to DOJ and say, hey, we're hearing about research, is this really a thing? DOJ says, yes, it's really a thing. And actually, it's a serious thing, and you should care about it. And I've seen that, like, firsthand represented in how some of these bills are forming and being updated. The FDA, I think, has recently announced that they are working on a project. They want to better understand how the agency should handle cybersecurity, particularly looking at things like how people push updates and that kind of thing, vulnerability disclosure again. It's, that actually is a huge departure and super proactive of the organization. And, for us in the community who've been talking about security issues for a long time, we have a tendency to get frustrated over the lack of action in the government and to feel like they're behind on talking about this. Do I smell really bad? This entire area has cleared out. You guys are lucky. That was it. Kumbaya. They were really worried I was going to start holding hands. I understand. But yeah, so actually, the fact that there are federal agencies being really proactive about this and, like, trying to get a grip on it and wanting to talk to the community is fantastic. As another example, the FTC is in Vegas. They're speaking at Black Hat, I believe, tomorrow. And they're talking about how you can work with the government. Unfortunately, the title of the talk is How You Hack the Government, which is a little sensitive in recent light, but I think it probably wasn't when they submitted the talk. But yeah, so you should go to that talk and you should, think about how you could work with the FTC and help educate them. Okay. Does anybody know where this is? Nope. Yeah. Thank you. Yes, it is, Alan. Well done. So, the Wassenaar arrangement. Has anybody here heard of the Wassenaar arrangement? All right. So this is one that I care about quite a lot because Rapid7 supports the Metasploit project, which is apparently the poster child for the Wassenaar arrangement. So Wassenaar is an export control arrangement amongst 41 nation states. The US has been part of this since 1998, and the Wassenaar arrangement covers weapons and dual-use technology. That's what it was created for. In December 2013, the members all met, and they agreed to add 2 new categories. One covering surveillance technology, and the other covering intrusion technology. Now, a lot of the surveillance technology conversation came out from things like Finn Fisher, Gamma Group Hacking Team, and I think actually, generally speaking, within our community, it's not that much debated. I think most people are kind of on board with the surveillance piece. This is getting to the point where I might need to sit down. So I'm not going to talk too much about the surveillance piece. On the intrusion side, the original goal was really that they were concerned about the sale of 0 days. And they were worried, again, from a human rights aspect, about how 0 days were being used by non-democratic governments against their own people and potentially against the governments that are members of the arrangement. The challenge with this is that I think, bless you, I think there was a little bit of a lack of comprehension of how complex intrusion software is, and the fact that intrusion software is not by default offensive. And so there was a thought that they would be able to draw a line between defensive and offensive. How many of you think that that is realistically possible? All right, so it does. It comes down to the pesky intent problem, yes. So this has been a challenge. So a number of the member states have rolled out VASNR with actually very little response and very little focus. But the US recently pushed a proposal for it, which actually, like, firstly, I think we should just acknowledge the fact that the US didn't just roll it out. Like, the other member states that have rolled it out, they just pushed it out, right? They were just like, we have it, we're going to do it, it's this. But the US wanted to get it right. So they created a proposal. They actually had a comment period last year, then they created a proposal off the back of that. They put the proposal out, they opened another comment period. And the proposal has some pretty major issues. The major issues would make it pretty much... so it would make it very, very expensive for anybody making security testing tools to do so. It would make it difficult for any multinational to do security testing across all of its assets internationally. And it has an impact for security research. Again, there I am, beating the drum about research. But it does have a serious impact, and a completely unintentional one. In fact, in the language of the rule, they expressly say that they don't want it to impact research. But again, this comes down to the complexity of the topic that we're dealing with, and the fact that these are people who deal with export controls. They're not security experts. And so the good thing is that during the last comment round, the Bureau of Industry and Security got 200 comments in. And those comments gave them a lot of food for thought. So their plan is to come out with another proposed rule and open another public consultation period, which actually is a really unusual thing for them to do, and it sort of demonstrates their commitment to working with the community and trying to find a solution to this. There is a lot of engagement. I would strongly urge you to get involved if you're interested in this topic, and if you work for an organization that might be impacted, which, as I said, is pretty much every organization, I would try and help your organization understand the impact, because this one actually could have some nasty unintended consequences. Again, I think people will probably ask questions on it, so I'm not going to sort of blather on about it too much. So, how can you get involved in all of this? Well, as I said at the beginning, I think that it's really important that we have a collaborative approach and that we want to work with people. So this, probably not the best idea. And actually, we see a lot of this. So, VASNR is a perfect example where there were many people with pitchforks and flaming torches, and it really doesn't help. Of the 200 comments they got, the first 100 or so were just people ranting at them angrily with not a great deal of understanding of what was really happening with the export control. And, again, why would we know, right? We're not export control lawyers. We don't necessarily know the complexity of that, and export control law is unbelievably complex. As somebody who's had to spend a lot of time looking at it recently, it's a pain. Right. But on the other side, they're not security people. So we should also have a little bit of compassion, a little bit of empathy here, and realize that we actually can only get to the right outcome by working together. So, that said, what does that mean? And I'm sorry, this is where my slides get wordy. So the first thing is, there are people who do know about these things. When I worked on VASNR to begin with, I talked a lot to export control lawyers so that I could get up to speed on that. When I started working on the CFAA, I worked with civil liberties groups, I worked with lawyers, I talked to anybody who would talk to me who knew something about this topic. I even talked to the guy who wrote it. So talk to people who are already engaged. Talk to people who have more experience, who know what they're doing. Figure out what they're doing and figure out how to get involved. There are lots of pockets of activity happening, and generally speaking, there are people looking for other people to help. Look for comment opportunities and participate. A lot of the things that I've talked about today have had comment opportunities. Vassanar has had one. The Dmca has had one. There are people writing letters about CISA and the concerns there. You can sign on to relevant letters. You can sign on to petitions. You can start a petition. You don't have to start one on the White House website if you don't want to do that, but you can start your own thing. Throw up a website and have a letter that people can sign on to. There are lots of ways you can do that kind of stuff. Identify relevant contacts. They're public servants, so it's actually not that hard to find people. You just need to go online and start looking. The best way to do it is to understand if there's a bill you're interested in, which committee does it come out of? So, for example, with CISA, it came out of the Senate Intel Committee. So in that situation, you might look up who are the other people on the Intel Committee that are not the sponsors of the bill, and you might think you would kind of contact their offices and share your concerns with them. Now, in the case of CISA, it had a committee vote that passed 8-1, 12-1, whatever the number was. One person said no. And so in that case, you might look at that and think, all right, so the committee is not going to be the best place to go. So where do you go? So you look at the topic and you think about who are the other core committees that are going to be interested. And I'll tell you, for cybersecurity, there are 4 main committees that I would look at. 8 if you consider House and Senate side. So there's Intel, is a big one for cybersecurity issues. A lot of things come out of them, but they're really focused in areas that relate to the intelligence sector. So probably not like broad reach stuff like research, that kind of thing. Homeland Security. This one is pretty self-explanatory. They care about issues that relate to Homeland Security. So anything that you can tie a national security angle to it, which there is a lot of with cybersecurity at the moment, you can get them interested. And there is a lot of interest and discussion there. Judiciary. Anything that relates to crime, Judiciary care about. In fact, they own it. So if you're looking at the CFAA, that would be the Judiciary Committee. That's what they care about. So that's who you should go talk to. But they also care about how law enforcement uses other existing laws or new laws. So, for example, going back to information sharing, because there's a law enforcement angle there, Judiciary is going to be paying close attention. They're going to want to understand how law enforcement would be using it. And then the last one is energy. Not energy, commerce, sorry. Which on the House side is energy and commerce. So commerce care because they have to think about, one, how organizations are behaving, and 2, what the consumer protection issues are around that. So you can look at that and think, if you're talking about something like cars, that they're going to care about that stuff, and you want to get involved with that. If you are unsure, having talked about all of this stuff, reach out to your local representative. They have a responsibility to listen to you, and they will. It actually sounds very cliche, but it actually does work. And the last thing is the EFF has an action center that gives you some tips on this stuff. Go and check that out. And talk to the EFF about how you can get involved with stuff. Okay. So if you're going to do something, where do you start? What do you do? There are some basics. As I said, do your research. Really get to grips with what you're talking about. Talk to other people who know about it. Generally speaking, the people who are engaged in this sphere will always help other people who want to get engaged. Because amplification of sound is good for all of us. But if you are going to get involved, you need to be on message, or it can actually pull in the other direction. So that's the first thing. The second point, I would say, is a little counterintuitive for a lot of people here. The reality is, if you just go to them with your pitchfork, they're not going to really want to talk to you. They're going to want to hide under their desk. Whereas, if you acknowledge the things that they got right, even if it's only an intent that they had. So, when I first looked at the International Cybercrime Prevention Act, I thought there are quite a lot of issues here. But I understood what they were trying to get at, and I actually supported what they were trying to get at. So I said, I like the fact that you're trying to shut down botnets. That works for me. But you might want to consider how you could do this piece so it doesn't do that thing. And so that's the thing, is if you frame it so that you show empathy for what they're trying to achieve, then they're much more likely to feel like you have common ground, and they're much more likely to want to work with you on it. Make your feedback actionable wherever you can. Provide recommendations. Don't just say, this sucks, I don't like it, but say, you might want to strike this piece of language or narrow this definition. Again, when I went through the ICPA, I was very prescriptive in the changes I suggested, where I could be, which is not everywhere. As I said, I don't have a good definition for authorization yet. Avoid jargon. This is tough. We do not like to drop our technical language, but we have to use simple language. We're in the habit of laughing at people in DC for the language they use. They use that language because they're talking to the public, and they use the language that resonates with the public. You want the public to care about these issues, use the language that's going to help them do that. Be courteous and helpful. I would hope that you generally try and be courteous and helpful with everybody. But if you want to work with people in DC, this is kind of a must. Nobody's going to want to work with you if you behave like a child. And recognize that they are experts at what they do, not what you do. This is a really, really big thing. I don't know very much about drafting law. I'm not supposed to. They know about drafting law. If I can help them understand our stuff, they can take care of the drafting the law piece. That's the way to think about it, is like you need them. It's a symbiotic relationship. Okay, so I typically have an Archer slide, and I didn't have one before, so this is my you can ask me questions. Questions?
Hi. Who is the primary lobbyists that you're seeing for a lot of this abuse security legislation?
Sorry, who's the primary lobbyist that I'm saying?
That you're like, which industries are primarily lobbying lawmakers to make these laws?
Okay, so there are security companies. Most of them are lobbying for things that actually impact their ability to sell and to do business. So they want information sharing, they want liability limitation, that kind of stuff. It's all relatively self-serving. And those security companies tend to be sort of primarily in the intelligence spaces or the incident response spaces, that kind of stuff. Then there are exceptions to that, but that's the majority. Then in the private sector, I would say a lot of the financial institutions and the big retailers, they lobby because, like, anybody who is a really big organization that is a high-value target and that is struggling with cybersecurity is going to be lobbying to try and, like, address some of their issues, particularly as they face liability. So financial, retail, sort of, huge manufacturers, those kinds of people. And then the last one is technology companies, like, so particularly people like sort of Google, Facebook, Yahoo, those kinds of folks. They tend to be more focused on, all right, I'll make a reference. They tend to be more focused on privacy issues. The heckle that I just got was Oracle. So Oracle is very active in DC. They do not speak terribly publicly about their activity. And generally, they would disagree with pretty much everything I just told you. They are not keen on reforming the CFAA to help security research. So yeah, but hopefully that might change over time. Yeah.
I have a second question. You mentioned the Wassenaar Convention. In December 2013, they had this discussion. How long generally does it take for things to be added? Because you mentioned that was in December 2013, or now August 2015. Did the controversial proposal that the U.S. pushed, did that ever get committed, or?
Right. So the way it works is, with Wassenaar, that the committee meets and they vote on something. And I mean, they can discuss it at plenaries, like, for an extended period of time. I believe that the way it works is that the vote has to be unanimous. So it actually, something can be raised at the Wassenaar meeting for, like, years and not be voted in until it becomes unanimous. But I've never been in one of the meetings, so I don't know. But once it's voted in, it's then part of Wassenaar. It becomes one of the categories that Wassenaar covers. But each member state has basically their own timeline to figure out how they're going to implement it. We have, by being part of the Wassenaar arrangement, we've made a commitment to sort of abide by the rules that everybody votes in, and if they've been voted in, then we should support them. But at the same time, we have to do that within the framework of our own legality and economy, and so that's where the nation states basically take it away, and then they figure out how to make it work. And the timeline on that can vary. I don't think there's a hard and fast timeline. I don't think there's a hard deadline. But I do think at the same time that if you have made a commitment to be part of something, then there comes a point at which it becomes a little embarrassing to keep going back to the meetings and being like, we're still working on it. So my guess is that BIS would like to get to some sort of resolution soon, but I think they would also like to get to the right resolution.
So it wasn't unanimously.
Sorry? I think it was unanimously approved, because I think that in order for it to become part of the arrangement, it has to be unanimous, but I'm not 100% certain on that. Again, not a lawyer.
The other countries that just sort of implemented that part of Wassenaar, where we went forward and we've put through two common, that's the one law that I'm working on right now. Yeah. And do you think that the other countries are going to take a look at what they put forward once they realize how different what we end up at? Because I know the revisions we've gone through, and it's going to keep going.
So
do you think they're going to revisit?
I think there's a couple of things that will happen. Firstly, I believe that the challenges that the U.S. has faced will force a conversation. I don't necessarily think that the US will go back and say, we have to get rid of this and tip the table. But I think that they may go back and say we should revisit the wording and look at how to implement it in the right way. That's the first thing. The second thing I think is there is a great deal of scrutiny right now. I know for a fact that the EU is looking at how the US is dealing with this and is trying to understand what the implications would be. And so I think that we will see a lot of countries really struggling with this. That said, I also think that the US has a number of unique challenges with this, because the sheer scale of the US economy, coupled with the fact that pretty much all of the companies that make penetration testing software are based in the US, coupled with the fact that the US has more multinationals headquartered here, coupled with the fact that even if you compare an economy like the US to the entire of the EU, you've still got a situation where in the EU, you don't need licenses to export within the EU. You don't, and when you apply for a license, you're applying to your government, your nation government, not the EU. And so just if you look at it this way, the sheer number of license requests that BIS is going to have to process is just it's actually kind of terrifying. I think they're probably wondering how they're going to do that. So I think there are some pretty unique situations that make the US's implementation different, that has created much more pressure on the concept of the rule.
Kind of a lot smaller question. You were saying that it was a lot more likely for the spy car, something regulated to a very small industry getting passed soon. How terrified should we be that that's going to be something that's like a wedge that then gets broadened later?
So I think it's always good to be vigilant about how law evolves. And I don't think it's ever a case of it being one and done, that you can just be we worked on this bill and now it's done and we don't need to care anymore. That said, I think that with something like spy car, the intent is fairly narrow on it. The focus is fairly narrow. It's unlikely that they would sort of update it to make it spy car and fridge. But, you never know. I think, that said, I do think that something like spy car would create a basic template that could be applied to other areas, but I think that they would only apply them where they felt like there was serious implication to do so. So, potentially medical devices or critical infrastructure systems where it's kind of a case of life and death. But I think generally, it isn't really the desire of lawmakers to make to sort of create lots and lots and lots of volume of law. They have enough issues to deal with, frankly. But yeah, I do think it could be a template. Okay, well, if we've got no other questions, then, okay.
Have you looked at all at how the EU NIS initiative, the Network Information Sharing Initiative that's pretty close to being done, is going to interact for multinationals in the US?
No, but that's really interesting. And I basically focus on the US, and I basically focus on federal at the moment. It's a scale issue. I'm me. And I have a day job. So I primarily focus on that stuff, but I think that in time we will be looking at those things, and I definitely think, like, the reality, one of the biggest challenges that lawmakers have at the moment, and the reality that we live in, is that creating these laws in a nation-state context when you're dealing with something that is not nation-state specific is a huge challenge. And we're seeing that now with something like ECPA, for example. You know, how do they deal with law enforcement accessing information that is housed overseas? And we're just going to see those challenges come up more and more and more and more, unless all of a sudden we decide to balkanize the internet, which I really hope we don't. So for those of you who are interested in these topics, I basically pulled out a number of other talks that I think might be relevant to you. I highly recommend some of the I Am the Cavalry track, which is all day today. Alan's talk this afternoon at 3, we'll be talking about that NTIA initiative around vulnerability disclosure. For those who are at Black Hat, there are a number of talks that look great, and I would strongly recommend coming to hear the DOJ speak about the CFAA tomorrow at 11:30. And just for what it's worth, like, I think this is actually the first time they've ever done this, where they've sent somebody to a security conference to talk about this law. So it's a great opportunity to come and ask questions. And then DHS is speaking about information sharing at DEF CON. Thank you very much for coming. I appreciate it.